We have a fair number of students here, so I'm just gonna kick it off with, let's say you're an entrepreneur and you've just kicked off your company. What's the most important action to take in terms of legal? So just do a quick, 2-minute lightning round. Don't do your typical lawyer 3-hour answer, please. What's the first thing that they should do if they're an entrepreneur who just formed a company?
Are you saying what it's like to call?
A little bit.
Well, to me, I mean, it would be different in every single case, just without getting needs are. But certainly, making an assessment of what kind of IP you have, just simply identifying it, is probably it's a crucial step. But in my view, it's probably what they all do first, just so they can start making decisions about whether to protect it or how to protect it. I think that probably necessarily includes getting a lawyer on your team to help you with that. Dustin?
Yeah, definitely looking at if you're developing something that you think is unique product-wise, looking at whether that's potentially patentable. I mean, there's obviously trademarks, copyrights, and everything, but patents are time sensitive, so the clock starts ticking, and it's better to file patent applications before you actually take something to market. So that's something early on that you should be looking at for sure.
I have two things that would tie. One is clear the name before you get married to it, because if you have some name that you're super excited about and tell everybody, and then you come to me and I see you can have it and be sad. And the other thing is, if you have people that are designing your logo, designing your website, putting pictures up, anything that will make you liable to somebody else's copyright infringement claim, or somebody else's right to listing claim, or what have you, you really need to make sure that you own that logo. The graphic designer you get on Fiverr owns it by default because they made it. You sign an agreement, you pay the money. It's not a fee for hire. So there are a lot of things that I echo what you said, inventory, because there's way too many things to list when you're starting a business that can go horribly wrong. And I hate having people come around with surprise when they do. When all of these things happen, and they put the blood, sweat, and tears and their life savings into something, and they have to pivot and it costs them.
So I think what everyone said is spot on. I think one thing, having been on the business side first, so we effectively, I worked at a small 15-person company, and we made Wizard of Oz dolls, we made toys. So transitioning to law, what I would also say is understand as much as you can and learn as much as you can about some legal stuff. Just spotting some basic issues will help you. So even before you're ready to kind of hire an attorney, so you don't have to kind of waste your time and their time going through, just get some basic, some basic understanding. And assessment is key. I really think knowing what you have, because if you have limited resources, especially, where are you going to spend those first dollars? Like if you have something that's patentable and you can protect that patent, you may want to do that. Or if you have this amazing name and you only have so much money to spend, you may want to first protect the trademark. Because ultimately, what you want to do is create something, protect it, and then make money from it, whether it's through licensing or selling direct.
Yeah, but we're taking advantage of these kinds of programs. If you're a minority, a woman, a person of color, there's some program that can help you. There's California Lawyers for the Arts. Spend those dollars first, and then use the other money that you might have earmarked for that on something else, so you can get more bang for your buck.
Yeah, does any of you want to comment? Are there other programs you would want to share? That young entrepreneurs, student entrepreneurs, poor entrepreneurs can take advantage of?
In addition to this one, SCORE is another local organization that's it's SBA funded, and so they link you up with mentors free of charge. So you get a lot of free resources, free assistance through that program. Sure, that's the first one.
What I will say is, don't hire a non-legal company, who shall remain nameless, to do your legal work. Either read everything yourself and figure it out yourself to save money, or hire somebody who knows what they're doing. But there's so many entities out there now that will take your money, do absolutely nothing for you, or screw up and lose your rights, and you have no recourse, and all the money's down the drain, and you thought you had the registration, and you literally had nothing.
Yeah. Yeah, you mean like those invention companies that like, hey, come in, I'm gonna talk to you, and, you know, then you're spending all this money and you're not getting anything for it.
And frankly, like for me, my rate is actually equivalent with 30 years of legal experience to some of these companies. So you're not saving any money.
How do you know which ones are legit and not? Like, what's the word, like a telltale sign?
Research, definitely look at any reviews, ask people, you know, you're in a unique position, especially the students here, that you have opportunities to ask each other and then ask the mentors and ask the people that work here. They should be able to help.
But just be careful asking your sister's boyfriend's brother-in-law's neighbor that did something once. And will tell you the wrong thing, and you think like, oh, I have to copy 10%, it's the 10% rule, I'm okay, it's not okay.
Right, and then obviously when a lawyer does specialize, right?
Please.
And so is there a special designation for, you know, that they look for online, or how would you know you have the right intellectual property attorney and stuff?
With your patents, you have to be registered with the US Patent and Trademark Office. Trademark, you know, I would just look again at someone's website. You can look on the USPTO, you can look at the attorney and see how many, you know, trademarks they have, you can look at blogs, articles. I mean, I found essentially when you talk to someone, if they know what they're talking about, you know, you kind of clue in. You're like, oh, okay, they get it.
That's uspto.gov, and you can search and say, Stephanie Pottick, how many patents has she filed? Trademark, sorry.
That's okay.
Yeah, you can search by the attorney of record, and if they have 5 to 20, I would be a little leery. Not saying you have to have hundreds, you know, but my concern that I've seen recently is, especially since COVID and slightly before that, is there's a lot of people really good at marketing and a lot of people at subscription models, and they are good at all these things, and they have maybe 2 years of trademarks under their belts, and they go out and they talk about, you know, oh, you can do this and watch my video, and the problem is you don't know in 2 years all the things that can happen on the trademark side. One thinks it's super easy because it's not technical, but it's actually a very nuanced. I still learn things after literally 3 years doing this before the internet, and so it's not as straightforward as we think it is. It's a murder.
And I don't want you guys to jump in, but I also think just asking the attorney or the person that you're working with or considering working with, ask lots of questions. You should feel comfortable and you know, just, they should be happy to answer all your questions. So definitely make sure that you do that. Because ultimately, there are a lot of choices. You want to be happy with who you're working with, that they want to get you to the finish line and they know what they're talking about.
Okay, we'll circle back to Eric. When does an entrepreneur know, or how can you figure out if there's an idea that's actually patentable, or, you know, how do they figure that out, or what's the best course?
Well, I think, number one, a lawyer, if you have a patent lawyer, that lawyer can help you do that. But also frequently, you have, is this thing working? And then they go over. You frequently know an inventor, somebody who invents something, is an engineer, and they have a lot of them have a lot of previous patent experience, and they know what they're patenting, and or they know what they're inventing and whether it either might be patentable or not. And so, at least for patents, that's kind of what comes up to my mind. Trademarks and copyrights as well. I think kind of going on what you all were talking about earlier, you know, and that's number one, go get a lawyer. But if you've got you come up with a name, you should know, I think that Stephanie was saying, learn a little bit about the law. Go out and learn what a trademark is versus a patent and a copyright and the things that will fall into those categories. And I think that will help you understand maybe when you have some protectable intellectual property. But go learn that so you will understand that the name of your product, that is something that is subject to trademark. You need to make a determination of, are you free to use it, number one, but that's where a lawyer will come in. Once you understand whether you're free to use it, you can start down the road. But Stephanie, I think you were, Lynne, I'm sorry, you were saying earlier, don't start down the road with something that you're not 100% sure about, because invariably a year down the road, 2 years down the road, after you've blown through all kinds of money and effort and expense and other expense, you'll finally get a lawyer, or you'll get a lawsuit handed to you that you're infringing someone else's IP and you can't use it. And 6 months, year, or however long, is just completely wasted. Got anything to add?
Yeah, I mean, on the patent side, definitely, I mean, people are inventing things, they've been in that industry for a while, so they are familiar with what's already out there in that industry. Though, I think the current statistic is something like 80% of patents that get granted don't actually make it to market for one reason or another. So I have seen situations where I have a client that's an expert in their industry, they've never seen anything like what they've invented. We do a patent search, and sure enough, something similar was out there 10, 20 years ago. It just never made it to market, so they never knew about it. And so it's good to do that type of searching. There's a lot of free tools you can use, like all the patent databases that I search, I don't pay for them. They're all just, every country has a database you can search. The easiest one is Google has their own patent search engine. You can search Google patents, and then you can get to it that way. It works just like the normal Google search engine. So like if you have an invention, whatever terms you can use to describe features of that invention, you type it into the query, and then Google Patents will return any published patents or applications that use those same terms. So if you're good at describing your invention, you can do a search to see what else is out there that use those same terms, because ultimately you get a patent that your invention has to be sufficiently unique. It's kind of what it boils down to. I won't get into the legal standards, but that's essentially what it boils down to. And so you can do some of these searches on your own, at least as a first step, to see if you're able to find any dead ringers or things that come close. And then you can talk to an attorney at that point, have them review whatever you found, have them do another search and confirm your findings. And the same is true on trademarks. There's trademark databases you can search. Though it's trademark can be very nuanced. Like it's not enough to just, I can't start selling shoes under Nike and just add an extra E to it. So you're not looking just for identical marks, you're looking for confusing and similar marks. You have to look at the underlying goods and services. Are you in similar markets? I mean, there's a whole multitude of factors you have to look at to see if this mark is too similar to somebody else's mark. And so, as Eric said, Stephanie, and everyone here actually, you want to make sure that you're free and clear to use something before you actually invest time and money. And if you get with a cease and desist letter 2 years down the road, now you're spending more money having to rebrand and pivot, recondition your consumers that, hey, now we're this name instead of that name. It's just a whole headache you can avoid by doing this due diligence right at the outset.
Yes. But I was gonna say, when I came to talk to Cynthia's class, she said, can you just do a search for us and show us how it works? And so I do the search, and the girl gives me the name, and I'm like, that's me, my client has. I said, well, tell me what the goods and services are. Exact same business. Oh, that's it's like to the letter.
You send her a cease and desist.
But it was just a pretend project, for class. So the point being, it completely, was like a perfect suite. This is why we do this, and it's phonetic equivalents, it's foreign equivalents, transliterations, all of these can block. So don't think, oh, I have this kanji character and it's totally different and it doesn't look like anything else. And the translation of that, I already trademarked those exact same things. you can use if you have a logo design that you already own because you came and saw somebody about the copyright issue. You can do a reverse image search in Google and see, is there anything out there like that? And you go visit those web pages and see, are they doing something like you? You just need to be very mindful that no matter what it is, don't think that it's okay to use because it doesn't look very cool, or it's like, I've had some letters that were like literally a picture of an ant or a picture of a leaf or some black and white circle, and you're like, how the heck does somebody own that? Well, they do. And on the copyright side, you know, if it's from 1926 forward or whatever, it's 1927 now, it's covered by copyright. Anything that's fixing the tangible medium, period, end of conversation. Do not assume that it's cool to use just because you saw it on a website and it didn't have anything that said you have a payments.
Yeah. Excuse me, I just have one thing to add. Everyone is spot on. Google is your friend. Google is your friend. Look up the name, especially like a trademark. So if you're like, oh, okay, and you want to go to an attorney, but I always tell my clients first, it's like, okay, if you don't want to, you know, spend the money or whatever it is, search it up front. If you find something similar, if you have, you know, table and, you know, for restaurant, and then you see like 5 table more, you know, you Google and you're like, table, restaurant. You're like, oh, move on, you know, that's the next one. And Google definitely search, and then the reverse search, like Lynn said, that is just a game changer. The stuff will come up as similar, and you could be like, oh, I didn't realize that. Or, you know, and then
What do you mean by reverse search?
oh, that you, so in Google, there's an image search, so you just copy and paste or drag it over whatever it is, and then Google will search that image, and they'll find things that are similar, which will be really helpful for you.
And one caveat though is, just because you don't see that exact same thing, or you see something that feels different to you, does not mean it's cool to use it. So I get people all the time, they're like, well, there's one company, but they only make shoes, and we're never gonna make shoes, we're gonna make clothing or jewelry or cosmetics. It's like, well, how many designers make shoes and clothing? How many designers make shoes and perfume? Lots and lots and lots. So these are related goods and services, and you need to just be mindful of that just because you don't see the exact same thing out there, doesn't mean it's,
Yeah, that's a great point, that's a great point, but at least it can help you spot, you know, like really, you know, stuff that's definitely gonna be complex. That's good.
Okay, so let's hear like some of the worst stories or examples of entrepreneurs pitfalls with trademarks. Without naming names.
I'll jump in, and this was actually a copyright issue, so,
That's fine.
I figured that we're covering all be here today. I had a client, that, and I don't know if you all have noticed this, but this happened about 3 times with me. Clients who had hired fairly young, recent college graduates in the sort of 23 to 25-year-old range, who just didn't have the experience or the understanding of what copying was. And this particular client had this 23, 24, 4-year-old kid, super nice kid, smart, and he was tasked with some social media, and they're building some platform for a new launch. And this kid just went out and copied a couple of images straight off the internet, dumped it onto the website. It was only up for about 48 hours, and they got a letter, a cease and desist from Getty Images. Because Getty Images, you all may not know this, but it's not just, well, Getty's kind of the gorilla of the group, but there are other humongous picture photograph repository companies like Getty, but they 24 hours a day, 7 days a week have these search bots that scour the internet for unauthorized use of their staple pictures. And sure enough, they found my clients within 48 hours, and we had a cease and desist letter. And I can tell you the amount of the settlement, but I won't tell you the name of the company. $90,000.
Wow.
48 hours worth of use.
Wow.
I've never seen one sell for less than $8,000.
Wow. I have.
And I mean, how many people, the product hadn't even launched yet, it was, they were up and they were, sort of beta testing this new website. But it was certainly out there for the public, they just hadn't announced it in a formal marketing kind of way. And I don't know, 20 people may have seen.
And if you don't take it down, it's one, you can't just break the link to that page, you have to actually remove it, because if someone types in that thing that's like 90,000 characters long, and it still comes up, you remain, on the hook until that comes in. So I think people need to know, don't just make it an error message, but if you can, it's not pointing to it anymore, but if you type it in, it's still up, and collecting the images, essentially.
I will say, so I've dealt with that same situation. If you don't listen to Eric and you still download stuff that you don't know, you put on a website, if you get a cease and desist letter from the Getty Images, don't just run off and pay what they ask for, because a lot of times, and I don't know if you run into this, but they don't actually go through the registration process with the Copyright Office. And so in order for someone to actually sue you for copyright infringement, let's say I take a photo and someone used it without my permission, I have to register that photo with the Copyright Office first before I can actually sue somebody for copyright infringement. And if I wait longer than 3 months after that photo's been out in the world, and then someone infringes it, and then I register it at that point, I'm limited to what's called actual damage, the actual dollar amount by which I've been damaged. As opposed to if I timely register for technically what's called statutory damage, and that's where you get these crazy dollar amounts that range up towards like $150,000 per work infringed if it's willful. But a lot of times, like with Getty Images, they receive so many photos, stock images on a daily basis. They're not going through the registration process, and so they'll send these cease and desist letters asking for tens of thousands of dollars in settlement, but they haven't actually gone through that registration process. And so what I usually do with clients is I'll go in and back and ask, okay, well, show us the federal copyright registration for this image. Half the time they just run around in circles, dancing around the issue. They never actually provide that or provide the registration number or anything. In those cases, a lot of my clients, I don't advise it, but they just ignore it. And Getty Images never follows through with an actual lawsuit, because I mean, their whole game is let's send out thousands of letters and let's hope that 10% of them actually pay. The rest of them are just these photos and then actually file suit. Again, that's not always going to be the case, but all that's to say that if you do get one of these letters, talk to an attorney before you do anything to see if you even need to pay something, or get it negotiated way down from 50,000 down to $1,000. It's like a nuisance dog at that point. But yeah, I mean, to avoid all that, don't use something that you don't own or that you don't have permission to use. So pay for those licenses, or take the photo yourself, or pay somebody to take the photo and have them transfer the ownership in that photo over to before you use.
Yeah, so when I was talking about the amount that I was saying, I never saw it settle for arguments and register. I'm glad you brought that point up. Only one with the registration. So you definitely want to check that. I agree. But you also don't want to let it linger, because many of these people that do have the registrations, they can prove their actual damages. It's like, if you want a photo that's this many pixels or whatever, a 1-year license is X. If it's so many, if the resolution is higher, then it's $5,000 per year. And for a year and 1 day, that counts as a 2-year license, right? So you don't know any of these factors until you dig into it, and you don't know if it's not answer if it's if it is registered, you don't want to answer that. You just need to. I always tell people, it's not a matter of if you'll pay, it's how much, right? The bottom is $750 for statutory damages, $750. I would write that check with a smile on my face every day of the week. I would know it's gonna be, I know, my hourly rate's $500 an hour. It's like, I have my time, and I would just pay it, and then move on with your life, and just don't do it again. I had a guy who once listened to me, which almost never happens, and he had a situation like this. I discharged him for telling him how to fix it himself. He took the thing down immediately, went out the next day, and he took all these pictures all around LA. He had like a travel agent kind of thing or whatever. Took all his own pictures, put it back up, had his website for 2 days, all with fresh pictures, all that he owned the copyright. And I was like, you are amazing. I wish
I have a good story, but it's not as an attorney. So when I was in toys, one of the items that we did was a sand bottle, right? So we did a lot of arts and crafts. So one of them was the sand kit. We had to do little plastic bottles, you know, so you had to do molds and, you know, the design and then send it off to China and have them manufacture. So going back to your point about, you know, someone young's out of art school, and you're like, okay, you're doing the work, you don't think about it. We got a cease and desist letter from Volkswagen. Why? Because our little bottle, look, they argue, they sent a letter, hey, your bottle, your little sand bottle, one of 5 bottles in our little $9.99 kit. They argue look like their Volkswagen Beetle. So they sent us a cease and desist letter. And what we wound up having to do, I mean, you know, then you had to go back and you're like, oh, let's have a talk with the RFP department and kind of go through what you should be looking out for. But we had to, no, nobody did, but, you know, but it was one of those things where, here's what we had to do on the business side. We had to change out the model. So we had to, you know, create, and this was a while ago, so it's not like you do a 3D printing, you have to change the whole mold and create something brand new, and then sign the settlement agreement and pay them money. So that's what happens, especially if you have a product, if you're not paying attention up front.
Oh, and also one thing, when you have situations like that, you can find creative solutions. Like I've had people put stickers over things, you know, like somebody's mad about this one thing on the bottle. It's very laborious to sit there and put a sticker on every single item, or like in your case, maybe you put a trademark. It was, no, I understand the whole bottle. But let's say there was some little piece you could like snap onto it, so now it no longer look like that or whatever. There are ways you can kind of, you don't have to throw everything out or destroy it. They do want you normally to do that, but sometimes you can modify and kind of, you know, I guess find a common ground and sort the problem out without having to, you know, lose all that. I guess, good point.
Yeah, we have a question.
Yeah, so, hi, Larry Marcello. I have a question. So let's say someone puts up the images on the website and you could prove that nobody visited that site, nobody saw you, had no profit, and went around those images. That's still illegal, right? But I guess the follow-up question is what if they did, and like, it doesn't matter at all if someone like spend $100,000 on your website if you have these images, would you have to pay more for that? Or why are there some cases that are $8,000, nobody's ever $80,000 for just the use of images?
Well, there was, in my case, there were several images, it wasn't just 1 or 2, but, and they registered.
Yeah, statutory damages are statutory, period, end of conversation. So it's between $750 all the way up to $30,000, and then all the way up to $150,000 per violation if it's willful. Doesn't matter. They have a concept of innocent infringement, but it's a defense to a copyright lawsuit that you're already in. And that's going to be burning money like there's no tomorrow once you're involved in a copyright lawsuit. But the standard is substantial similarity, access and substantial similarity. If anybody could access it and substantially similar, then it's a smoking gun.
Yeah, intent is not part of it. It doesn't matter if anyone sees it. It's a strict liability.
And just actually following on, what Lynne was just saying, there is no such thing as consent. I didn't know, I didn't need to, I didn't think I was infringing. Even, you know, if you give attribution, that's still.
Yeah.
Yeah, so if you find something online that says copyright John Smith, take it, put it on your website or wherever you're gonna use it commercially, and you say, John Smith owns this copyright, you're still infringing. You're not, that does not get you off the hook, and a lot of people think it does.
And there's no percentage. People say like, oh, you just use, you know, 3 bars of the song, or it's less like the less than 10% rule. I don't know the person who thought about it. Like every time I hear that,
We change it.
so you think exactly.
Like,
It's like Vanilla Ice, which I, you know, something you don't know or whatever. But it's like the whole like dun 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 dun. You know, he got sued for just that many notes. It's not a whole song has to be infringed. It's just substantial similarity, period.
Fair use law. The fair, talking about the fair use law. So I've used it a few times, had no issues with it, but the idea is that, you know, a non-commercial, you know, those are the rules thing together, but especially now that you got better AI and just write everything that's out there, you can see who's doing whatever, everything else is out there. But the idea, the concept is that when you're non-commercial, informational, and you have nothing that's out there, just has a reporting kind of informational thing. And they're going backwards now, so you have a lot of scraping things done from all over the, world is coming out of a lot of people in the States. Your experience with that?
I would never, ever, ever count on fair use.
Yeah.
Ever.
I'm not asking to count.
Yeah, so my take on that is it's incredibly difficult and even, people think like, oh, like, here, we're giving a talk and we're being instructional, so therefore the, educational exception applies. No, it doesn't. I'm not a teacher at a full-time university or, a newsworthy, it's like, oh, this is a newsworthy event. And there's many cases, there's one where a woman was murdered, and she happened to be a former Playboy playmate, and they reissued the pictures, and, the court said, look, her dying is the news, not these pictures from 10 years ago. So there's no safe, like, slam dunk, you're totally fine, fair use, it's this. With the O.J. Simpson trial, there was a guy with a cat and mouse act, and the court said, that's not fair use. It's, you're not making fun of Dr. Seuss, you're using his, style to make some money. So I would just say, that's just, if you have to use it, of course, fair use is something you want to look into if you're on the defense side, but I would never, ever counsel my clients, say, oh, yeah, sure, you can do that, it's only fair use, because again, you're already defending once.
There are limited exceptions under fair use, so it's very case specific when it comes to copyright.
It's about minimizing the fee, because to your point, there was someone who was 30 years old that I hired who was exceptional. And she created the art, but unfortunately, don't go to the thousands. We have one side, something 5 years later, we found one. And I said, was a non, I found fair use law and I applied it. They walked away, but to your point was, I intentionally don't say, hey, let's use it.
Right, but in a lawsuit, if somebody's already invested, $100,000 suing you, they're not gonna just back out because you were, oh geez, sorry about that. I mean, they're for, exactly, you got lucky at least once, and that's fabulous, but I was thinking, we would not ever cancel.
And I'll just add one thing, and I think this probably goes for any IP. If you're using something or you think you're allowed to use it, even if you get, let's say you get sued, even if you win, you have spent a ton of your own money and a ton of your own time dealing with that lawsuit. And I promise you, if you're selling toys, you're not in the business of defending lawsuits. You're in the business of doing, selling toys or whatever it is you're doing. And so even if you ultimately end up being right, let's say you select a trademark and you go through the front end analysis, you're like, well, this is kind of close, but I think we win. That probably means don't use it just because even if you do win, is it worth it?
You guys should watch Flash of Genius with Frank Mir. It's a great movie, and it's about the guy who invented the intermittent wipers and what the lawsuit did to his family and his mental health and everything else, even though he was 100% right and had all the patents and everything else. But what I will say too, this is helpful, I think all of you, if you want to see GL policy, commercial general liability policy, and many of those, although they're changing nowadays, will have a, what do they call it, economic injury clause or whatever. Anyway, it will sometimes be a defense to a trademark loss. Go to Reese's too. Because I had opposing counsel in time. But there's advertising, that's what's called, an advertising injury clause. So if you're getting a CGL policy and you can get an advertising injury clause in there, put it in there, because if you do have to defend a trademark policy and you have insurance counsel going to bat for you, it's amazing. You have a free, it's basically a pro bono lawsuit at that point.
Yeah, that's a good point. So if you go, when you go into business, you should have some sort of insurance, business insurance, errors and omission. And to Lynne's point, part of that might be actually defense. So instead of going and hiring an attorney and spending the money, you can go to the policy and contact the insurance company and say, hey, you cover me for this? It's really a contract. The insurance policy is a contract. So just read if there's anything in there. And if you can, we did that. So again, on the business side, we had a lawsuit. I won't get into the whole thing, but it's, you know, at some point I thought we should just put a skull and crossbones on our employees because everything was just so, you know, you just had to put so many warnings. But there was a lawsuit and the insurance company did defend, but we wound up getting our own attorneys as well to make sure that our interests were being protected.
That we want them to.
Yeah.
Hello. Hi, Ray Allen, graduated in 2014 with my EMBA. Just to amplify what you're saying, my other question is, you can actually purchase IP insurance. And if you're, post revenue, you can actually collateralize that IP and try to raise money, to go to markets and actually get try to fund it. So just something for those of you that are looking for, bringing products to market, that's something you consider. I've actually gone through this process, this IP process. It's very long, it's very laborious. I think it'd be helpful if you could talk through the different steps. I know there's a provisional patent, and a PSC patent, and your full patent takes quite a lot of time. It'd be good to understand the protections that each patent provides for you. As you go through the steps. Again, I'm bringing a medical device to market. It's been 4 years of doing R&D and going through patents and all those type of things. And we're still years away from getting full patent. And then also is how do you determine what geography to do the patent, right? It's going to be based on sales and where you think you can have the largest volume of sales. But again, you need to consider just the US, you do Europe. So just kind of talk about some of these topics.
I'm gonna need about 2 hours. Yeah, I mean, so as far as like where to file, I mean, it's really gonna be industry specific. I mean, you always look at like, okay, where's your big market's gonna be? US is usually the big market for most. Europe might be another big one, but then beyond that, I mean, electronics, maybe South Korea, Japan, I mean, Australia, sometimes that's sometimes file there. But it's gonna depend on the industry. We also look at, aside from where your big markets and maybe secondary markets, where might this product be manufactured by competitors? So, because like the patent's going to give you the right to stop someone from practicing that in the country where you have a patent. So like if I have a US patent, no one can make, use, sell, offer, or sell my patent didn't mention in the US. They also can't import infringing products into the US if I have a patent in the US. But if I have, let's say, a patent in China, if that's where knockoffs are being made, now I can stop the knockoffs at their source by getting patents there. And so it's really gonna be case by case, but for all my clients, the starting point is filing in the US. And then you've got a period of time then within which you can file, kind of string together applications and file in other countries through what's called the PCT process and everything, which we won't get into those weeds, but no, usually, especially for startups, you can start with a provisional application. Essentially like a placeholder where you file this invention disclosure basically with the patent office here in the US, and that holds your place in line for up to a year. Meaning that within that year's time, you follow up and you file a full, what we call the utility patent application or the non-provisional. And then if you do it properly, that non-provisional gets backdated and it's given the same filing date as the provisional. So if I file my provisional today and I file my full application a year from now, that full application is going to be given today as the filing date. And where that's critical is that when, as I mentioned earlier, in order to get a patent, your invention has to be sufficiently unique. Well, compared to what? Basically compared to anything that came before your application filing date. So if I file my patent application today, let's say my competitor comes out with something identical tomorrow, well, my application filing date predates that competitor's activities. But if it was reversed, if my competitor came out with something yesterday that's similar, and I file my application today, that competitor's product can be taken into consideration as what we call prior art. When the patent examiner then looks at my application to say, okay, is this sufficiently unique or not? They'll see this competitor's product and they might conclude, well, no, it's identical, or it's too similar to this competitor's product. So again, it's all about getting that application filed and getting as early a filing date as possible. And so you can start with a provisional, relatively minimal cost. I mean, depending on who you work with, you definitely want to work with an attorney to some degree, even if it's a provisional, because you want to make sure it's done right. If it's not, when you go to later file that full application, you might not get your filing date if you don't do things properly. So start with provisional, you have a year, up to a year if you want. When you file the full utility application, it depends on what industry you're in, what technology you're working with, like mechanical devices usually are sitting in the patent office for less time than like software. It's definitely gotten better, but still I think the average is about 18 to 24 months from the point you file your full utility application until it gets picked up for examination. But like when I first started, it was taking like 7 years for software. So I mean, it's definitely gotten better. And also, if you have it in the budget, you can pay an extra fee to the patent office to expedite the application. So rather than waiting 18 to 24 months, if I pay, it's a little under $1,000 if you what's called a micro image. It's like 800 and change. But rather than waiting 18 to 24 months, you only have to wait about 3 to 4 months. So it's a way to really fast track the process. But yeah, otherwise, the whole process could take 2 to 3 years to get through. And meanwhile, you're what's called patent pending, meaning you have a pending application that's hopefully going to be issued, but you don't have any enforceable rights. So in other words, you cannot sue somebody for patent infringement unless and until you have an issued patent in. And so, but again, in the meantime, your patent pending, you can advertise that. It's a little bit of a deterrent to competitors, makes them think twice before you just go ahead and rip you off. It's a little bit of a marketing tool as well to your customers, but did I answer all your questions?
You did.
Okay. I appreciate it. Yeah.
If I can add a couple of things. One, you want to make sure if you have a trademark for that patented item or the one that you're trying to patent, if you don't blow the date by putting a first use date on the trademark, that's going to conflict with your patent and make it null and void. And when your patent ends, even for a medical device, I have a client for medical device and aftermarket automotive part that we have ornamental element, and we could do a three-dimensional trademark, and we could get a product configuration trademark that like the day the patent ended, somebody in China was just starting to pump out these things, and we were able to shut it down with this product configuration trademark. So that's what to do when the patent ends. And then the last thing I'll say is a lot of people think that the PCT patent and the trade protocol trademark are exactly the same. And I'm here to tell you that you should never do the trade protocol trademark. You can help it. They are a nightmare in every way, shape, or form. The national application in the countries where, you're making the manufacturing something definitely in China, it's pharmaceutical, food in India, do it where it makes sense. But I've just seen so many people get burned for so many reasons with the grid protocol trademarks, the international registrations. They are not the same as a piece. Pieces are awesome, but grids just, I've seen more problems. I mean, I could talk for 3 hours. I just wouldn't do that.
All right.
Thank you. Yes, I'm Mario, and my question in this digital world that we have, is there a strategy between you go for the domain name first and then you trademark your product name, or vice versa, or at the same time?
I have some thoughts on that. So, excuse me, what I advise my clients is when you come up with a name, try not to share it. If you really love it, spend the money on the domain, because there are some places that you'll look at a domain and somehow the bots know and they'll buy it and then they're happy to sell it to you. So if you like something and you Google it and you're like, oh, it kind of looks, maybe it's available, get the domains, get similar domains, get the plural, get, a different spelling, whatever, get the social media, because, check it out, see if you see what you can get. And then, I would kind of do it. I mean, just because the trademark takes longer because you've got to do a search, I would immediately jump on the domain and the social handle. And, if it doesn't work, no harm with that. You have to pick something else, but that's so inexpensive.
If I can ask just a quick follow-up. With trademarks, we tend to go in and obviously engage an attorney, and we do it for the US. Extend that more globally, because if you're thinking of taking your product outside of the United States, are you doing the trademark search in other countries, or is it not the simultaneous?
Yeah, I mean, it really depends, and I think the point was brought up, and I just want to say from this standpoint, when you're manufacturing, especially in China or in other countries, having a trademark there are competitors who will get the trademark before you and then stop your product from, they'll use it for their customs, so you can't export. So there are a lot of considerations, but yeah, I don't know.
More than that, I was on the enforcement committee, for China, the International Trademark Association, and we had Chinese judges come up and talk to us and talk about the system. The Chinese applicant can get a registration for $35.
Wow.
If you oppose them, they will almost always win. Out of all the opposition and cancellations I've had in China, only for one client was I able to get the trademark back. We even tried to buy it for like literally hundreds of thousands of dollars, and the deal went through not once but twice. It fell apart. It's a nightmare. So you really want to, and no matter where it is, they're going to be selling your stuff out the front door in the daytime and the knockoffs out the back door. Apple could use, still to this day, can't use iPhone for iPhone cases. Airbase was fought over 22 years over their trademark in China. New Balance couldn't sell their own shoes there. It's not even just customs, it's just a cost of doing business. I would absolutely, if you're gonna have, and even if you think, oh, I'm never going to sell in China, I don't care. You should just, it's $1,000 to file, just do it. Right? It's you don't, the headaches are far too much. It's getting better. But I would say, China, India, Turkey, if you're selling leather goods, you want to do Morocco, just wherever it is, all the rest of the world is first to file. And you just don't want to give somebody that opportunity. I had a client that did tie-in barbecues for backyards, and somebody had filed for every single barbecue manufacturer and gotten a registration of this one entity, and then had this like janky website where they were selling these like crappy products, and just literally stole everyone's trademark. And you could do more about it now than you could 10 years ago, let's say, but it's still miserable.
Yeah, it's definitely, as I was saying earlier, as far as like the patent stuff, you find your biggest markets, secondary markets where it can be knocked off. On the trademark side, you want to file anywhere where you're actually using the mark or having a product manufactured, because at the very least, even if you don't think you're ever going to spend money enforcing those rights, you want to make sure that no one's going to get those rights and enforce them against you. So you want to have what we call freedom to operate. And it's said, and that's why sometimes you'll see a company operating under one name here and a different name in other countries. Sometimes it's a translation issue, but other times it's because they literally can't if they wanted to, because someone else owns those trademark rights. And so when you file, usually you're going to file in the US first, and then you do have a period of time of 6 months where you can file in other countries, and then those applications will get backdated and be given the same filing date as the US application. So that way, if you file in the US today and someone in China files tomorrow trying to hold your mark hostage, as long as you file within that 6-month window, you're ultimately going to have an application file date that predates theirs. So you have this priority window is what they call it. And so definitely if it's something after you file in the US, talk to an attorney and figure out, okay, where else can I file within the 6-month window.
And find out if they have connections. A lot of people that are part of this International Trademark Association, we've made friends for 30 years. I have someone in almost every country, and they'll tell you things like, no, you should not file that, and here's why. Like, for example, in Chinese characters, I think, and I may be misspeaking, but like 4 characters would be bad luck. But 3 characters is like good luck. You don't want to have a trademark where the transliteration is something everyone's going to avoid, like the plague. Like the Chevy Nova example. It's like, why would the Chevy Nova selling in South America? Well, it means no go. Why would somebody buy a car that won't work? So you want input, before you kind of branch out into the world.
Hi, I'm Kat. I'm a student intern here at Leatherby. There might not be a concert answer to this, but I still want your opinion on it. Last week we had a panel where these couple of guys from the technologies came in and they were talking about AI. And I wanted to know, are there any like intellectual property laws around like the digital media, or like any laws we need to know when it comes to content that's made by AI?
There's some big issues. I mean, the law's going to catch up just like everything else, with digital advancement. But there are a few things you should know. To get a copyright, you have to be a human. So if you heard about the monkey selfie, the monkey didn't have rights to the picture because, you know, it wasn't human. So if something is generated using AI, it's not copyrightable. Questionable, you know, how much the human would have to change it, modify it, or, you know, AI does a little bit. That's one issue. The other issue is if you put something into AI and you get, you know, you're like, okay, great, I have this picture, this image, this story, it could be infringing on someone else. So you have to think about that as well. And I think the other big issue, I mean, again, just issue spot. You don't want to put any trade secrets up there. I think it was Samsung. Did you hear that story? Samsung, one of the employees, they were working on code, wanted to figure out what was the next logical, you know, sequence to the code, and put it in. So it was a trade secret, and no more, because now it's out in AI. And of course, I'm sure we all heard about the attorneys that were sanctioned, I think, was it in New York? They're like, here AI, tell me what cases support my position. And AI is like, here attorney, here are your cases. And then gave it to the court. You made it up. They just made the AI made up the cases. They weren't real. So you really kind of have to know those issues when you're working. For inspiration, great. Give me 5 ideas about, you know, what blog I should write about trademarks or whatever it would be. But then, you know, I still shy away from it for those reasons.
Just a follow-up question on that. What do you foresee for the future of IP law for AI? Like last week, one of the guys spoke about maybe watermarking any media that's created by AI. What do you think is going to be the solution going forward?
I'd like to know what you all think about this. I think it's, I think they're gonna have to do some sort of compulsory licensing like they do with music. I just can't imagine how they're going to get around it because you're gonna have so much content out there. So I think eventually it's, I don't know how easy it will be, but.
I guess,
Yeah, I'd like to see like a, you know, the digital housekeeping seal. I'd like to see something that's kind of far-fetched, but something where it's like certified human made. Because I was just reading out there about, there's just gonna be, like you said, so much like too much content to sit there, like a tsunami of content. And it's almost like, you know, you go to Italy to have someone hand make your soup. Like, I would like to see something. Yeah.
I guess I have a follow-up question. If so you mentioned that the machine makes it's not really copyrightable. What if you beat the machine like 10 paintings that someone did to create another game? So they're using all the information they have. They're creating creating a machine using that.
No, it's still the machine that's making that final work. And then it's steps. I mean, you're running into what we call a derivative work, where you're essentially making this new work, but it's based on other people's prior works, and without those other people's permission, you're technically infringing their copyright.
Yeah. So let's even say that it, you know, there was just a little bit from everything and it wasn't discernible that it was infringing, you still wouldn't be able to own it. It still wouldn't be copyrightable.
Yeah, and the same, and who knows, I mean, just like any other area of law, it's always in flux, we'll see if that changes,
Yeah.
but the same rule applies on the patent side, where you can't have AI listed as an inventor, you can only have human inventors on a patent application. If you list an AI, it's gonna knock it out, and so, again, I mean, then you have to look at, okay, well, are people gonna start being less than truthful as far as who created something, who invented something? You just like leave, if it was AI invented, or are they just gonna list a human instead? And I mean, examiners, the patent office, they're going to start asking more pointed questions if they think that there's a chance that something was invented by AI rather than a human. Basically prove to us that this was invented by humans. Yes, so far, if it's not created or invented by a human, it's not protectable under US IP laws.
But on the flip side, I would also caution you, like, let's say you told the bot or the AI company, whatever, use take 3 Disney princesses and more than in one or something. You might be infringing all 3 of those works, and to say that, you know, if it's not discernible, well, it's maybe discernible to, you know, whatever software Disney has to see infringers, you know, if it's infringing or not, and they've already won several lawsuits based on this. It's kind of like when people say like, oh, I paid for this photograph. It's like, yeah, but did you read the terms and conditions? Because the photograph terms and conditions probably say for your own personal use on your, you know, wallpaper on your desktop computer, right? But if you want to use it for commercial purposes, it's $25,000, $25. And so similarly, if you take this AI generated object or photograph or whatever it is, and then you start selling calendars with these or what have you, now you're on the hook for copyright infringement and or trademark infringement, because many of these characters, those trademarks plus these copyrights. Yeah, and if it's based on an actual human, then you go to a whole other can of worms, which is right publicity, which we don't have time to go into here. And I would be mindful of the whole.
Yeah, no, I agree. When I was saying not discernible, I wasn't saying, hey, yeah, for sure, but yeah, you shouldn't feel that it's, you know, that it's not going to infringe. I don't know, I did I was on a webinar given by the Copyright Office, and there were a lot of frustrated people on it. They were trying to explain like what would be protectable and what's not when it comes to AI. And one of the things they said, and I thought it was a great example, but I don't think a lot of people appreciated it, but it kind of made it a little more clear. So let's say you write a book, you've written a book, right? You wrote a book, it's your book, it's your copyright. If you put it into AI and translate it into Spanish, that translation is not copyrightable. And then you go, wait a minute, it's not copyrightable, but you kind of have to look at it in the big picture because your underlying work is still copyrighted. So if you have something that's copyrighted, then you know you have 2 choices. You can hire someone and get a work for hire, make sure you own the translation, or if you use AI, you won't own the translation. Can someone copy it? No, but it's kind of like a very nuanced, interesting, you know, area.
But I would submit to you that you don't want the AI one anyway, because I just had a situation with an examining attorney where they were trying to say that the client took like a half English, half Spanish sort of word and made a new word. And the examining attorney is trying to get us to do a translation, you know, to admit in the record that it means this, and it doesn't mean that. It just doesn't. And so the examining attorney had looked at one, not Google Translate, but some other translation. Every other place that I put it in came up with a different, like the examining attorney just picked a 1 out of 30 that said it means this, but it was just wrong.
Right.
And so it's still an imperfect art, these translations, you know what I mean? So you would wanna just, you know, if you are giving content and you do want it to be, you know, worldwide and want to get copyright on it, then I would suggest what you did, which is hire someone that would translate it, you know, more eloquently, and appropriately, and then get a copyright. But I will say one other thing on copyright is when you get a registration in the US, and this I use for enforcement, in China and other places, if you have a US registration under the Berne Convention, any other country that's a member of the Berne Convention is supposed to treat your copyright registration here with enforcement effect as if it were registered in that national country. And a lot of times that can help me if I have, you know, somebody that's infringing and we're struggling on the trademark side, but the trademark plus the copyright, and we have it for the logo or for the character, whatever, I can kind of get us over the hump and then get them to come to the table and pay us their stuff.
I have a question. So let's say I take a picture of a sunset, but then I go and post it on Facebook. My understanding was that there's like an agreement in Facebook that says whatever you post there, they own.
It says that they don't infringe your copyright by having it, like they can reproduce it and not be liable, but that doesn't mean that I can go to your page, cut it, and then make it, you know, splash it all over my products without paying you. I can't do that, you know.
I would say that anywhere that anywhere you license something or social media, each one has their own terms of use and license and ability for you to kind of go in and look and see, oh, what can I do with it? Or, you know, I would go there. This is exactly.
Do you have any other questions?
Other questions? Anybody have? Okay. Go ahead.
When you're talking about the terms and conditions of a picture, I was wondering, how does that even come about? Like, is that something that you discuss with your attorney when?
So if you find something online, you don't know where it comes from. If you go to iStock or Getty Images or something like that, you can go into their terms and conditions. You're like, oh, I like this photo. How can I use it? You know, so if you sign up and pay for their license, but there are different types of licenses. Lynn was saying earlier, and it's true. So my favorite copyright story in the world is the Mike Tyson Hangover 2 story. So just to give a brief, I just love it so much. So essentially, who owns the tattoo on Mike Tyson's face, right? Mike Tyson, the movie studio, the tattoo artist. Anyone? What do you think?
Tattoo artist.
Exactly, tattoo artist. So he was sitting, I imagine he was sitting one day watching commercials and saw the Hangover 2 promo, and Ed Helms comes out of the bathtub with Mike Tyson's tattoo, which is really his copyrighted tattoo. So he called his lawyer and they filed a lawsuit to stop the movie from coming out, which the judge was like, no, I'm not gonna do that. But he said, hey, tattoo artist, you have a decent copyright case. I'm gonna let this case move forward. So what happened was they settled. And I can imagine that the guy, I was thinking he's sipping a pina colada and sitting on his beach house, because, the DVDs and the movie and, streaming, whatever it is. But, when it comes to that, so I would go and speak in front of groups, and I wanted to use a picture of Mike Tyson. I was like, oh, can I use that? To your point, is it fair use? And I'm like, I don't know. So I contacted someone at the company, and I said, I'm just gonna do a presentation. It's not a newsworthy, it doesn't fall into newsworthy, but I'm not doing anything. Guy's like, no, you can't use it. So the point is, whatever image is there, sometimes you have to see exactly what it's for. So if there's a picture of Mike Tyson, it might say editorial use. So you can only use it if you're a newspaper or you're doing some sort of real, reporting. But otherwise, it's either, an image and there's nothing there, you won't know. Or if you go to a company, you can go to their website and look at their terms.
So that reminds me, if it has a person in it, and I don't want to. There's a concept called right of publicity. It's not federal, it's state by state. Some states have it, some don't. Some only protect military personnel, some protect it 100 years after the person dies. So don't assume that if it's a picture of somebody who's dead or long dead, that there's no problem. One time we had someone speak at our law school, and he was on right of publicity, and I called him up afterwards because I wanted to ask a question, and it happened to be Bela Lugosi's son, who's very famous in the world of right of publicity. He's super lovely, and I remember I called him in October, and he said, well, I asked him a question, and he said, well, I got around because it's my busy season. And I thought, of course, because your dad was Dracula, and it's comedy time. But the point is that even if it's something from silent films, or whatever, don't assume that, hey, there's a copyright, and don't assume that because the person is dead, that there's no issue with using that particular image.
Yeah, the estate, because there are states, maybe licensing, they have valuable rights and they license out on consumer products and other things. So that's, it's one of those things also, actually, you bring up a great point. So Lynn brought up a great point, and I just want to put it out there because people are always asking me, if you go to a site and it says that the images are free to use, they might be free to use, but you still have to look at the terms and conditions, because in there, it says if there's a person, or like there could be an image of Mickey Mouse, doesn't mean you can use it. So you really have to be careful all the time. And if you don't know, if Justin said it, and just do it.
Yeah, there's a famous case where Humphrey Bogart heirs sued Burberry. Burberry bought the copyright to a photograph that showed Humphrey Bogart wearing one of the Burberry coats. But they didn't address the right of publicity. And they said, hey, it's just our Facebook timeline. It's not an advertisement. It's not commercial use. And that's like, well, obviously it's commercial use because the Burberry, sorry. You can't say it's not commercial use. You're that when you're that kind of caching. So anyway, I agree with everything you're saying. And a lot of times people come to us And marketing and legal are always war, because whatever sounds fun and cool and interesting and is gonna draw lots of people to your business is gonna be terrible from an IP legal perspective. You know, it's like, we're gonna have a contest and we're gonna have kids singing songs and having videos of themselves, and they're gonna have this in the background and pull up and say, oh my god, there's so many, I can't even.
Yeah.
You got minors, it's a radical, it's a medical, you got copyright, trademark infringement. Oh my goodness, you know, you really have, and don't think because it's an avatar that it's fine, don't think because it's a hologram, it's fine, don't think because it's AI, it's fine. None of those things are true. I mean, even virtual worlds, you've got like, so, it's just a minefield if you're trying to do much.
I have a question.
Yeah, actually, mine was just sort of all along the same lines. Is there some aspect of commercialization, since sort of able to describe it? So, as a professor in the classroom, if I would take, photographs off and sort of, don't have copyright, shoot it. And, but it's not commercial use. Are there exceptions? Because it almost seems like any presentation PowerPoint that you put out, photographs would then be that aligned with it.
I always tell people, if you're speeding on the freeway, you get pulled over by a cop and you're like, "Oh, these people are going so much faster than me." Does that carry the day? I mean, yes, there's rampant copyright infringement, and rampant trademark infringement, and rampant intellectual property problems, and not everyone gets caught. Yeah, but do you want to be the one who gets caught?
No, but I guess I'm trying to think deeper on, isn't there a commercialization aspect?
I mean, it's,
Well,
I was just gonna say, I think you're talking about fair use in the.
yeah, and if it's not, if it's commercial in any way, it's almost impossible to find fair use. But if it's not commercial, especially if it's like in an educational context, like if you're teaching class or something, you've got a PowerPoint. I mean, it's probably gonna be fair use, but also like, is it gonna be something that gets the attention of the copyright owner, and whether they can be bothered enough by it to actually take action. So, I mean, the reality is that if you're just teaching one class and you've got one photo in your PowerPoint slides, you're probably not gonna run into any issues.
I mean, I completely understand the commercial portion.
Yeah.
That one makes complete sense.
But also, I've had, you guys can back me up, I've had nonprofits that are out there doing the Lord's work and helping, underprivileged children with no arms, and they're still getting sued for infringement. So what I'm saying is, do not count on that, I mean, these people are not making money at all, so don't think that it's not commercial.
Although I have a question, did you hear about, Kat Von D, the recent case? Kat Von D had done, a tattoo of Miles Davis based on someone's photograph, and she posted her doing the tattoo using the photograph. There was the photograph, there she was, there was the tattoo. And a jury in Los Angeles found that it was not infringement, that it was fair use. So to Marius' point.
I thought they said it wasn't substantially
It was-
similar, which is kind of not.
That it was a different medium, which, that would be, and then she made no money on it, and I just thought, I can't even, what do I even say about this?
Transformational, it was so bad, it was transformational.
Honestly, I think it's because it was a jury decided it, and maybe they didn't understand the copyright law, but it just, to me, it flies in the face of,
Yeah, and I will say one other thing that you guys probably experienced, and I hate when the clients tell me this. Oh, it's internal use only. It's just gonna be for our employees. It's just, basically we're saying, oh, we're gonna rip it off, but we're gonna be really quiet about it. Make sure nothing is inside only. Everything gets, or you're gonna get a trade, well, we're calling it this, and then we're gonna do trademark, we'll do the search later, and then we're gonna rename it. No, you're not. Because your distributors, your suppliers, your potential, everyone's already notified that name. Nobody wants to change it at that point. It's never gonna get fixed. So don't think, well, it's just for us, or it's just internal. It's not.
well, I find that most people come up with a name, to your point, Lynn, and then they just fall in love with it, and then you have to tell them that it probably won't work. And they don't want to hear it, there's nothing, there's nothing we can do at that point, it's very hard.
I had a client call and ask me, can I have this mark? And I looked and I said, absolutely not, and here's why. I mean, okay, fine, didn't hear anything about it. Came to me and said, hey, can you help me get this trademark back? I had this other lawyer and he did it and, he missed the deadline and now we need to do petition to revive and do their month's office action. I go, there's nothing to fight about. These are the two that I told you can't have it because these two period end of conversation. And it's like, well, he said, we went with him because he said he could do it. And I said, well, you call him and have him make whatever magic arguments he's gonna make that are gonna get around this too, because it's not happening. Like, I don't know what to tell you.
Yeah, but it's a good point too. You want to make sure that you're working with people who are looking out for you and not just gonna tell you what you want to hear. I think the saddest story for me, when it comes to trademark, is someone came to me and said, we were talking about other trademarks. They said, oh, I have a trademark. And I said, oh, great, because you can easily look it up. So I'm like, and I was like, ooh, it was dead. They never renewed it. So I said, it's not active anymore because it wasn't renewed. He goes, what are you talking about? It's like, you have to renew it to keep it active and alive. And he was just devastated and arguing with me, but it is what it is.
So my client had the same situation. The trademark died, they reapplied, and now they're blocked by someone else.
Yeah.
Which is terrible. Someone else that they gave permission to use that mark. So my client is marked A, this one is B. These are for goods that are, let's say they're for cows and this is for horses. And the trademark office is saying, no, you can't have it. But when they did the deal, the consent letter, it wasn't mutual. So they told these guys, sure, you can have it, it's not a problem for us. But now we're blocked by them, so I won't get a letter of consent back from them if they are owned by somebody else now, or somebody else says no, my client's out of luck. And I can't get, even though they were first, they've been using it since 1994, and these other people are more recent. What are you gonna do?
Hi there. So obviously tonight we've been talking a lot about protecting intellectual property, but just in the nature of protecting businesses, do you recommend that people get a legal entity outside of themselves, outside of sole proprietorship to protect themselves? And does that give you any legal or financial protections for all of this stuff, or is that just kind of
Without question,
Yeah.
I mean. It might be insane not to. Literally.
Yeah.
Clinically insane not to do that, just because, I mean.
Unless you're just judgment proof, like if you own no assets and somebody can sue you and not recover anything, but.
Well, yes, also I saw a patent probate process over that was horrible, where the guy, the inventor died. He had married this woman who was the stepmother of his kids since they were like 2 and 3 years old. It was the only mom they ever knew. She got everything as the surviving spouse, but wouldn't transfer ownership to the family business that was entirely based on this patent that nobody can use anymore because they somehow got in a fight. And now, she's over here with the patent, no business. They have a business they can't run because it's not even licensed to them. I mean, it's a like,
Well, I would say that once you have exposure, you should definitely consider doing it, and you should talk to a tax professional because there are tax ramifications. So if you do a corporation versus, an LLC, and there are also different legal formalities, some might be easier than others. So I mean, I think that goes into it. And then even if you have the company, you have to follow the formalities, have separate bank accounts. And make sure that you have insurance. So, the more that you can layer on, the better protected you're gonna be.
And kind of following on what Lynn was just saying there, if that issue goes beyond divorce and probate and whatever have you, if you've got co-founders.
Yeah.
And let's say, it's you, the three of you sitting there as co-founders, and Boisineau, you've got the patent that you are bringing to the table, and your co-founders are putting in, $1 million each or whatever. That's great, but they and their lawyers should demand that you immediately assign all of your rights and interests in your patent to the corporate entity that you should form. So the entity itself owns the intellectual property, and then each of you owns whatever percent of the entity. So it's kind of direct ownership of the patent, but your other owners are absolutely going to want you to make a formal assignment of the patent from yourself personally to the entity. And that's essentially what the same issue that Lynne was just talking about. They're just in a different
Well,
context.
and one other caveat on the trademark side. Trademark laws are designed to protect the consuming public, not the owners of the trademarks. And if you have two trademark owners that split up and they each own as co-owners, and they're in a fight and one person is not gonna buy out the other person, the court will say, look, if you can't figure out who owns this, then nobody can use it. You're not allowed to have two separate businesses doing the same thing under the same trademark that are not under common ownership. That is like pulling the wool over the eyes. It's basically collusion. It's basically sort of an antitrust sort of situation. And to get in a mess like that and then untable from it, I've seen it probably half a dozen times in 30 years, and I would wish them any.
Okay, lightning round, last thoughts. What have we not covered lightning round? I mean, it's like 30 seconds.
Oh, gosh. What we not covered, we covered a fair bit of ground. No, but first of all, I think I would just reiterate, even though lawyers are cost centers for businesses, you need to have a lawyer to help you, competent lawyer to help you with whatever you need. I think, Stephanie, you mentioned earlier, or maybe I think both of us actually did, figure out, what are your marquee items that you need right out of the gate. You may have 10 legal issues that need to be addressed. Depending on how much money you have, pick the top 2 or 3 or whatever you can afford. Those most important ones, get them done. Get 6 months down the road, take care of another issue or 2, but you need to have a lawyer on retention. So that's really my main point. I think I would drive to any entrepreneur who was just starting out. It costs money, but you know what? Spending a little money up front can save you an absolute boatload of money down the road.
Justin?
Yeah, take advantage of free resources like this center, like I mentioned, SCORE, there's other ones out there. But yeah, definitely prioritize, sit down, think about what you have, what's worth protecting, what steps should you be taking. A lot of times, again, you can talk to attorneys or mentors, little to no cost. Like again, people, I'm part of this center. Eric here is, I'm sure Lynne and Stephanie would also be happy to answer questions. It's just kind of, figure out, prioritize what you have, what's worth or what you need to spend money on now versus later. There's a lot of different options out there as far as attorneys. I mean, small firms, big firms. I mean, so don't just talk to one and go with that one. Like talk to a bunch of attorneys, figure out who's the best fit from a cost perspective as well as just how they operate. It's critical to take these steps. So if you are starting a business that you're serious about growing.
I always joke that trademarks are the redheaded stepchild of intellectual property, so we think they're not as hard because it's not technical, and you can do it on your credit card, and it's pretty easy, and you do all 3, so it's not as easy as everyone thinks. It's a very nuanced area of law, and you're just being penny wise and pound foolish if you don't at least talk to somebody. You don't have to go with them, but get some parameters of, should I file, a color logo, black and white, and why would I file a word? Just this, just get some ideas of what you need to do, because you want someone that can scale up with you. You don't want some knucklehead that's been doing it for 5 minutes and doesn't understand, you want to be a franchise, you want to be franchises later on down the road, but you don't, it's like this is your family business. There's reasons why you do certain things differently. It's family business. You want someone who understands, to your point, the entire business, like why you would make something as a business decision, even if it's not the best legal decision, and why to do all those things. I like to look at things holistically, because what makes sense for one client is not going to make sense for another client, even though they're similarly situated. We've got these other factors that are key as to why you would do something different, and it's not one size fits all. And so we can listen to 1,000 lectures on trademark and still go wrong if you don't have someone really guiding you who's on your team and who wants you to succeed. You know, like I try to teach a man to fish, like I wanna teach him how to protect your intellectual property, so that I essentially put myself out of business, right?
I do the same, I empower my clients to learn, so they don't have to contact me as much, you know, just, you know, so you know. So I think we covered pretty much, oh my God, more than I even thought we would, but I think it comes back to that first point. Learn what you can, understand what you can. I mean, I created Protect for Success because for me, it's just these speaking engagements or just having that education that's accessible, you know, without having to learn the hard way. And I did Tony Robbins' Business Mastery, and it struck me, one of his forces is know your financial and your legal. And he told a story that he was spending a lot of money on an attorney, and you know, they just kept going through, and the guy didn't understand his business. And finally, one of his peers said, or mentors, had said, you need to understand because you want to guide them. You need to understand what the big picture is so you can make the best business decision. And I think that goes for everything. If you have a business, you're not just going to be thinking about the legal. You need to think about what does that do to the rest of my business? And I think that's really, if I can impart one thing, it's just to understand those different factors so you can make the best decision for you.
And I'll say one thing, I promise it's short, it's
Okay, we
something
still have, people are still here, good.
mainly,
Last thought.
mainly just because we've got a lot of new and younger entrepreneurs here. Be really, really careful about finding things online, like contracts, and
Oh.
thinking that you can get out of
Yes.
it.
Yes.
It just occurred to me, but you just see people find a contract online is titled the same thing they want, say, non-disclosure agreement, or intellectual property assignment agreement, whatever it is. And they would just take it, lock, stock, and barrel, and either change nothing or change very little. And invariably, 90% of it will either be irrelevant or completely wrong. Just don't take even good-looking, sexy kind of language online, probably just doesn't fit what you need. Be really careful. I mean, you can get yourself into a world
That's
that way.
important.
And that reminds me of one last resource. My son went to Long Beach Film School. They have a bunch of stock. They do have releases and things that are good ones that they pass out to the students. So I'm sure that any kind of film school can give you, you know, you'll probably be happy.
Yeah, professional resources, not just stuff in finds.
I just want to know where you're finding sexy contracts.
Just, good looking language that, it's all this legal jargon that, it sounds.
But lawyers
great. It
find
must be
sexy
good.
versus.
It's a secret.